Hello and good afternoon. Thank you all for being here. We hope everyone is well and staying safe. Today is Tuesday, July the 21st. This is the nuts and bolts of estate tax planning. My name is Ashley, Client Services Coordinator, and I have the privilege of introducing today's presenter, Vincent J. Russo. Vincent is the managing partner of Russo Law Group, Long Island's signature elder law, special needs, and estate planning law firm with convenient offices on Long Island and New York City. We are recognized as a best law firm by the US News, and we've had the privilege of helping over 17,000 families. Vincent is a co-founder of the Teresa Alessandra Russo Foundation for Children with Special Needs, which was established in the memory of his daughter, Teresa. He is also a founding member, fellow, and fifth president of the National Academy of Elder Law Attorneys. So before I pass it over, a couple of quick housekeeping items. I would like to mention that we are available to answer your questions. Please send them to us by way of the questions box provided in the Zoom platform. If you're joining us through Facebook, feel free to drop your question using the comments section. Finally, Zoom will open a survey page in your web browser after leaving the webinar. We would appreciate your feedback. It shouldn't take more than a minute or two, and we thank you in advance for filling that out. Okay, and thank you for your attention. Vincent, if you would, please take us through today's agenda.
Okay, thank you, Ashley. And so I'm really excited about this program, the nuts and bolts of estate tax planning. And as I started to think about, well, what would I cover? I realized, and then Ashley really made the point to me that, Vincent, you've got like 5 presentations all in one on estate tax planning. So we're actually going to break it out into a number of different seminars. And today, I'm really just going to cover the basics, the nuts and bolts of estate tax planning. Why should you pay attention? Even if you don't have a taxable estate is where I'm going to start. I'm going to explain what a taxable estate is and then why you should pay attention. Talk a little about who should do estate tax planning, and then mention some of the strategies, but that's really going to be the bridge to the following series of presentations because they can get awfully complicated and confusing. And the last thing I want to do is to confuse all of you. Estate tax planning is very important, and it's a critical part of any estate planning that you're doing. All right, so let's get into it. We're going to start with what is a taxable estate in 2020. So this is a situation where each year you need to monitor the size of your estate and the exemption that is provided under federal law and New York State law. If you don't reside in New York and you're domiciled in another jurisdiction, then you need to understand the estate tax laws that are applicable to you. They could be very different, such as a state of like Florida is very different than New York. Now, we're going to talk first about the tax rate at the federal level. It's 40%. So once you have a taxable estate, every dollar over the exemption amount, the government's going to take 40% away from you. The exemption amount is $11,580,000. So that eliminates like 99% of all of us from having a federal taxable estate. So that's really the good news. And the amount gets adjusted each year for inflation, so it does go up. So if you have an estate of under 11,580,000, 99+% of the population, there is no federal estate tax. Once you have a larger estate, beware, because now the government's going to put their hands in your pocket they in effect become a beneficiary of your estate. They may get more than your children. If you have 3 children and they got a third of the estate, now you have a 4th child, and they're actually taking more of a share than each of your children. Okay, so we understand the federal. Let's go to New York State. The top estate tax rate is 16%. And the exemption amount is not as good as the federal. It's $5,850,000. So you may not have a taxable estate under the federal rule, but if your estate exceeds that $5,850,000, then you are going to be taxed by New York State when you pass away. And then there's this quirky rule. It's really a punishing rule called the New York State estate tax cliff. And that amount is 105% of the New York State exemption. Beware, once you exceed that exemption amount of $6,142,500, New York State takes the exemption away. So every dollar is taxed from dollar number 1 in New York once you have an estate of $6,142,500. Now, these amounts will be adjusted for inflation, as I mentioned. And also, later in the program, I'll explain why you still need to pay attention even if you don't have a federal taxable estate, because the federal rules are going to change in 2026. So let me give you an example of how much the tax would be at certain levels. So at $5,850,000, there's no federal tax, no New York State estate tax. 0 estate taxes, great news. If you're at $6,142,500, no federal tax again, but look at that tax, New York State, $542,000, over $500,000. If you have an estate that's slightly over the exemption amount of $5,850,000. Once you hit 105% over the New York exemption amount, kicks in this tax. It's called the estate tax cliff. Now, at $11,580,000, good news, no federal tax. Look at this New York tax, $1,319,600. And if you have an estate, I'm going to double numbers here, of $23,160,000. I know there are not a lot of people with that size estate, but if you do, your federal tax is $3,363,040. New York, look at this, $3,172,400 for a tax of $6,535,440. That's a significant amount of taxes. Now, let's start with my basic first question. Why should you pay attention even if you do not have a taxable estate? First, the laws can change. So, new Congress can come in, a new president with the following in Congress, and we can see tax laws changing. Right now, we're going through COVID-19. Look what's happening to the economy. Look at all the unemployed people and the benefits of unemployment insurance that have been paid out. State and local governments are going to have deficits. So it might be Congress is going to have to look at this and say, well, how are we going to pay for all of this? And they could change the estate tax exemption amount at the federal level, or the states could change it at the state level. Not likely anything's going to happen until after the presidential election in November, if there is a change. The other important point is what I call the power of the step up in basis. Wow, this is really important. If you own an asset and it's gained in value, appreciated, and you sell it, you have a capital gain. And the federal government in New York State has a capital gains tax, and you're taxed. And ballpark, that's going to be around 26%. It could be as much as that, or maybe even a little higher. So when people are doing estate planning, often the client that we have in our office wants to avoid probate and save legal fees. They want to make it easier for their family to inherit assets. So perhaps they give those assets away while they're alive, or they add someone's name onto an account and make them the survivor. So let me give you an example of how terrible that potentially could be. Let's say I have an asset that's worth $500,000. Let's say it's stock in Apple. And I bought that Apple stock for $100,000. That's my basis. So if I was to sell it today, I'd have a $400,000 gain. 500,000 minus 100,000 equals 400,000. And the capital gains tax, I'm going to just ballpark an assumption here at 25%, $100,000. All right. So I take that asset and I give it away. When I give it away, the beneficiary of that gift, let's say it's my daughter, she gets what's called a carryover basis. What that means is that my $100,000 basis in Apple stock is now her $100,000 basis in Apple stock. And she now proceeds to sell it at some point, and she's going to have that capital gains tax. Could be more or less $100,000. Now, if I didn't gift that money to my daughter, but I left it to her through my estate and she inherited it, then there's this concept of step up in basis. The asset is worth $500,000. I individually had a basis of $100,000, but when I die, if the value of that asset is $500,000, then the value gets passed on to my daughter. She now has what's called a step up in basis, date of death value of $500,000. So if the asset's worth $500,000, her step up in basis is $500,000. How much gain does she have? Zero. How much capital gains tax? Zero. So rushing to transfer a house or a real property or appreciated assets, stocks and bonds, could result in creating capital gains taxes when you don't have an estate tax to worry about. So one of the solutions is, rather than give it away to make it easier for your family to inherit, transfer it to a revocable living trust that avoids probate, and you still get the step up in basis. So that's a good tip. Now, with people with assets over 5 million, I'm going to suggest that those are the individuals who should do estate tax planning. Why? Because New York State estate tax laws are not as generous as the federal estate tax law. And once you're over 5 million, you're getting to where that exemption amount tops out at 5,850,000. And so we would want to see and think about doing planning at 5 million. If you're at 6 million or more, I'm worried about the New York State estate tax cliff. If you're over like 11 million, I'm worried about the federal estate tax. So anyone with 5 million or more needs to think about doing planning. If you reside outside of New York, then it'll depend on the state you're domiciled in. We're going to do a follow-up presentation just on New York State estate tax planning. That's how complicated it can get. Now, if we're doing tax planning, then there are lots of strategies that can save literally tens of thousands of dollars. We've done planning where we projected savings of millions of dollars in estate taxes. So I'm going to break this up, level 1 and level 2. Tax planning opportunities. Level 1, make gifts to individuals. It takes the asset out of your estate. You will be using your exemption amount when you do that at the federal level. So that exemption amount I gave you before was both for gifts and for when you have assets in your estate. That's the exemption that would apply. Now, many individuals are not comfortable making outright gifts, especially of significant amounts. You can make gifts to trusts in a way where you can exert some controls over the assets or the management of those assets, protect those assets for the family member who still can benefit from the trust and the assets held in that trust. For individuals who have life insurance, this is huge because if you have life insurance, it's income tax free when it's paid out, but it's not estate tax free. So you would want to remove that life insurance death benefit out of your estate. And there's a vehicle called the Irrevocable Life Insurance Trust. And that's used all the time to take those insurance proceeds and get them out of your estate, saving literally, potentially hundreds of thousands of dollars. If you're married, there's a vehicle called the Credit Shelter and Marital Trust. And in your will, you can build in these trusts or in your revocable living trust. And this is a way of taking advantage of the exemptions in your estate and your spouse's estate. And we're going to do a workshop seminar just on that one topic. I can explain to you how you can save so much money. Now, if you have a larger estate and you really need to do additional planning because you don't want to make a gift to the government when you pass away, here are some ideas. Discounted gifts. How do I make a discounted gift? What is it? Well, I'd like to give away $100,000, but I only want to use $65,000 of my exemption. I want to discount the gift from $100,000 to $65,000. Can I do that? Absolutely. Through the use of LLCs, limited liability companies, or subchapter S corporations, where you have voting and non-voting units or stock, and you give away your non-voting interests in your LLC or your subchapter S, and there are formulas for how you can get a discount. Also, you can make gifts into a trust and have it discounted while you retain an income stream for a certain number of years. When you have more significant estates, dynasty trusts come into play, where if you leave assets to the next generation, your estate is going to be taxed, the next generation is going to be taxed. By the time it gets to the grandchildren, it's been diluted. It may be that you can you can set up what's called a dynasty trust, so maybe it's included in your estate, but won't be included in the estate of your children. And that avoids that second level of tax. Now, you may say, well, I don't have a lot of assets. Why would I even think about this? Well, if your children have a lot of assets, why would you want to add assets to their estate, creating a larger estate tax? I have a client right now where we're doing planning to avoid her inheriting several $1,000,000, and she already has a significant estate. Doesn't make sense. There's a strategy called spousal access trust. This is where you can make gifts out of your name to save estate taxes, but still your wife can benefit, or her husband can benefit, or your married partner can benefit from the income stream of that trust. So that can be very helpful. And then, of course, charitable giving. So if you leave assets to a charity, it's not subject to an estate tax. Or if you create a certain type of trust, you can get a charitable deduction for income tax purposes and keep assets out of your estate for estate tax purposes. So if you're charitably minded, charitable gifting and the use of charitable trusts can be so helpful. So those are just some ideas on tax planning where you could take advantage of these strategies to minimize or eliminate federal and New York State estate taxes. Now, just want to go over a concept of gifting before we move on. When I make a gift, and I said earlier, well, if I made a gift of $100,000, I use $100,000 of my exemption, and that for federal purposes. But if that $100,000 grows during my lifetime in the hands of the donee, let's say your child, and that asset grows to $500,000, then that gift of $100,000 avoided the additional growth of $400,000 from being included in your estate. So it's a way of leveling out your estate so it doesn't grow further. So if you weren't looking to do more significant estate tax planning, at the very least to reduce the size of your estate and reduce taxes, perhaps you want to think about at least holding the line where you are through the use of gifts. And if you're going to make gifts, you want to do it in the best way possible, and that's where discounting gifts can be so beneficial. All right, so with a gifting program, you can maximize your annual gift exclusion amount under the federal laws of $15,000. So you can give away $15,000 to as many individuals as you want to each year, and you're gifting that gift tax free. You're not using up any of your exemption. You also can make gifts beyond that amount, as I gave an example just before, and start to utilize your federal estate and gift tax exemption of $11,580,000. And as I said, that can shelter future growth from your estate and estate tax. You can consider gifts to reduce your estate below the New York State exemption amount at $5,850,000. There is no New York State gift tax law. So if I have an estate greater than that amount, I can gift down below that amount as a way of reducing or eliminating New York State estate taxes. Now, there's a hook here. New York State says if you do that, you have to outlive the gift by 3 years in order to keep it out of your estate from estate taxation. So deathbed gifts would not work to save the New York State estate tax in that situation. Now, when you're making gifts, as a general rule, you want to give gifts of little or no appreciation. As I mentioned earlier, if you give away appreciated assets, it creates a capital gains tax. Or it could be an appreciated asset, but you have no intention of ever selling it, and the person you gave it to is not going to sell it. So if you don't sell an asset, you don't pay a capital gains tax. Also, just remember, we got a balancing act here. Capital gains taxes are at a lower rate than the federal estate tax. So it may be that even if you do create a capital gain tax later on, it was worth it because you had a federal estate tax problem. So with planning, you can achieve significant estate tax savings. Let me just give you an example of a gifting strategy here. Let's say your estate was $11,580,000. It's a lot of money. The federal estate tax is zero. I mentioned earlier the New York estate tax is $1,319,600. Well, what would happen if, and you have to be comfortable doing this, you gave away to a trust, let's say, $5,730,000. That would reduce your taxable estate to $5,850,000. Let's assume you made the gift and you outlived the gift by 3 years. Your estate now is estate tax free. No federal and no New York State estate tax. A savings of $1,319,600. It's a very simple example of how powerful planning can be to save taxes. Now, I mentioned right up front that this federal estate and gift tax exemption is not in stone. In 2026, it is scheduled to return to approximately $5,900,000. So there are a number of clients who are doing estate tax planning now because they're fearful that in 2026, the federal law will not be extended and there'll be this reversion to a lesser amount, or as I mentioned, a change in Congress that could result in changes in the tax laws. So taking advantage of planning now may be a very smart decision. Now, is there a downside to making large gifts now if they lower the exemption later? And my understanding as to how the rules are right now at the federal level, there is no downside. So if I was to make a gift and use an exemption amount that's greater than what's permitted later on, there'll be no recapture of the earlier gift, creating an adverse tax consequence to me. So the good news is, if you do planning now under the existing laws, you get the benefits of the laws now and should not be punished later on for having done that. Also, there are a good number of reasons to do planning that are not tax generated. So I talked today about the nuts and bolts of estate tax planning, but I just want to remind everybody that there are non-tax reasons to do estate planning. Passing assets on to your family without problems, in a smart way through the use of trusts, without probate, creating additional legal fees, and especially leaving assets in a protective way for family. You worked so hard to have what you have. Do you want it blown or lost because a creditor claims, or your child has a bad marriage, or you have a family member with special needs? So things that we consider when we're doing estate planning for our clients with small estates and with large estates. Is there a family member with special needs? How do we protect them? Do you want to leave assets in a more protective way for your children? Concerns about creditor claims or a bad marriage. What about long-term care planning? So that if a loved one, a spouse, or an older family member, at some point, if they need long-term care, have we left assets in the most protective way so they can maximize government benefits? So I mentioned these strategies that are available for everybody. Think about it. Think about taking advantage of them. They can save significant estate taxes through a gifting program or the use of trusts. But I also, when I meet with clients, say, you need to make a commitment of time, energy, and there are going to be legal fees. There are going to be disbursements, out-of-pocket expenses if you're transferring real estate, forming a LLC, if that makes sense. And that's okay. But it's important that up front, when you meet with a planner, understand the big picture, make sure you are clear about your objectives, make sure the plan is responsive to your needs, and then you decide the cost-benefit analysis of whether it's worth your time, energy, and your money to save estate taxes. Simply put, most importantly, you need to be comfortable with your estate plan. Don't ever sign a document or transfer assets, make gifts, do things that you're uncomfortable with. So what do you do now? You create a plan. That's what you do. If you have a plan, you revisit it. You bring in qualified professionals, lawyers who specialize, have an high degree of experience in estate planning, estate tax planning, elder law, special needs. Our firm is always available to assist you. The key is to do something. Get your plan started and implemented, or if you know you need to make revisions, go ahead and get it done. Our offices are now open in New York State. So we are available to you. We are also still doing Zoom meetings like this one, or FaceTime, or by telephone conference, video conference, so that we can meet with you virtually. There's no reason not to go ahead and get your plan going, even if you're reluctant to physically go into an office. They've relaxed the rules on how to sign legal documents right now, so we can do it remotely. So it's done in the safest way possible while we're in this terrible COVID-19 virus period of our country and the world. So with that, we're going to open it up for questions, and I'm hoping that as you think about what you've heard today, that I welcome you to stay with me on this series. Once a month, I'll be touching on another level or aspect of estate tax planning. Okay, so do we have any questions, Ashley?
Hi, Vincent. We do.
Okay.
Carol had a couple questions about what is considered to be an estate.
Okay, so an estate consists of all the assets that you own. So let's talk about your name is on bank accounts, brokerage accounts. You own real property, so your name's on a deed. You own an IRA or 401k plan. You own a life insurance policy. You're a beneficiary of a pension. These are all assets of yours that become part of your estate. So we're always happy if you contact Ashley, send you one of our questionnaires, and you'll fill it out and you'll total it up. You'll subtract your debts if you have a mortgage on your house, and then you'll know the size of your estate. Now, for estate tax purposes, you treat life insurance as the death benefit. So if you have a policy that's term insurance, it has zero value today, but it'll pay out a death benefit when you pass away. Let's say it's $100,000, then that $100,000 is part of your estate. If you own assets jointly, in some situations, half the asset is part of your estate. And so like if you own real estate, two people own real estate together as tenants in common, that's 50-50, then 50% of the value of that property is in your estate. So There's a valuation process at the time of your demise that on the date of your death, there'll be a snapshot of all your assets and we'll figure out what the current value of those assets are and we'll add it all up, subtract any debts, and that'll be the size of your estate for estate tax purposes. Now, how do you know if you have a taxable estate? I mentioned way in the beginning that if your estate is over $5,850,000 in New York, then you have a New York taxable estate, and $11,580,000 for the federal. New York, if I'm going to go over that number again, it's $5,850,000. I want to make sure I said it correctly. All right. How much of your estate can you donate? This is another question, to charity and still leave your spouse the required amount by law if you have no children? Okay. So let's break that down a little. The question is about what's called the right of election. And so when you are married, your spouse, married partner, has a right in New York to 1/3 of your assets. So let's say you're married and you have $1 million. And you've been married a long time, but you're not really in love with your partner. Or your partner's been cheating. So you go to a lawyer and you say, I want to leave that $1 million to my children, and I'm not leaving the blank, blank, blank a nickel. And then you die first. Well, the blank, 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 the surviving spouse, has a right to $333,000, regardless of what your will says. So if you are going to leave assets or money to a charity at the time you pass away, then you have to take into account that if you have a surviving spouse, they're going to be entitled to 1/3. Now, I want to also put a nice picture out for all of you as well in that example. Let's say you love your husband and you've been married all these years, or you love your spouse or your partner and you're married, but you still want to help a charity, and your surviving spouse is going to have more than enough of their own money. And that often comes up with second marriages. So your spouse can waive the right of election. Now, you got to be really careful how you do it. It's a legal document, and we can help families in that situation so that the spouse gives up their right to the right of election, and then you could give away all of the money to a charity if you want. All right. Ashley, seeing any other questions?
No, sir.
All right, very good. So we're going to kind of wrap up at this point. And, okay, my little frozen here. Okay, so we're going to talk about what makes the Russo Law Group different, why you should consider coming to us. And so you'll see on the screen here some of the things we've done in our firm that I think helps you. And that's our job. Our job is to work for you and help you. So we have 4 convenient locations on Long Island and New York City. We're licensed in multiple states, especially, of course, New York and also Florida for a lot of the Florida snowbirds. We have seen over now, I was looking the other day, over 19,000 families since I started. And I'm not as old as Moses, but I'm getting up there. But we have a whole team. I have 5 partners. We have so much experience. We have over 20 staff. So we're really strong at handling crisis cases. And we're not going to learn on your account in most situations because we've already seen it. We've been there. And that makes it easier for us to help the next client. We also give family discounts when we're doing planning, and we have a special maintenance program for our clients. And we have gone even beyond. We've helped in the community. We've we supporting the frontline workers with free estate plans. And so we've created a COVID-19 crisis response page on our website. I'm 3 days a week doing a daily check-in on Facebook to just check in and talk about things that I'm experiencing and concerns that I have for all of you and how I can help. So that's our commitment. We're committed to our clients, caring about our clients. And as I mentioned, this is just the beginning of a number of seminars that'll be on estate tax planning. And also, Ashley, we basically do a webinar every 2 weeks, right?
Yes, and actually the next one in this series is coming up next month, August 18th.
Okay.
I'm
So,
sending an invite to everybody here through the chat window. If you'd like to go ahead and register, just click on the register in advance for this webinar link. Appreciate it.
all right. And thank you, Ashley, for all your help putting this together. You do such a great job. I hope everybody found this helpful. And my hope is that you be safe out there. Be careful, take care of yourselves as we all try to pull through this virus, this pandemic that we're facing. Be well and have a great day.